Mr. Keji, a legal practitioner, joins us next to shed some light on those judgments that we've been talking about this morning. Thank you for coming on again today.
So much for having me, John.
Well, the two groups seem to be sticking to their guns now, and one wonders, are they going to approach the Supreme Court for interpretation again? What do you think of this?
The case is already clear. I commend the last speaker, Mr. Ono. In my view, I think he did substantial justice to the issue. What came before the Supreme Court was the situation as at the Federal High Court, Port Harcourt. What happened at the Federal High Court, Port Harcourt? There was an interlocutory injunction stopping PDP from recognizing any other executive committee apart from the Oguebego committee. So, while that interlocutory injunction was still pending, the PDP went on appeal at the Court of Appeal, Port Harcourt Division. And that Court of Appeal application is still pending. Yes, it was still pending when they went ahead and inaugurated a new caretaker committee. Upon the inauguration of this new caretaker committee, just a few days after INEC had recognized the Oguebego committee, Oguebego ran to the Federal High Court again to ask the Federal High Court to protect the sanctity of its order. That is the interlocutory injunction that reinstated him, that says that he should remain as the ESCO. So it was that Federal High Court matter that now rose to the Supreme Court, not the substantive matter with regards to who is the proper ESCO.
But what he's saying too is that
Yes.
along the line, because eventually when the court now ruled, he now says, look, since I conducted primaries,
Yes.
and we had our own list of which we had submitted, that was a list that was going to be used for the senatorial positions until something went wrong, their list was substituted.
Yes.
So having gotten this judgment now, which says that he, Oguebego's group, is the rightful group to be the state EXCO, and by extension conduct the primaries for which you can then submit the names to NWC, then our transmission to INEC, which wasn't done. Now he says he wants that to be restored.
Okay, let me use an analogy. You see, in MNK and PDP and Okadigbo and Emeka, it was clearly held that the responsibility to conduct such primaries lie with the National Executive Committee. That is that. But look at this analogy. A political party is a corporate entity. It can sue and be sued in its own name. It is a legal personality. And as such, it can take a decision by itself. If it can take a decision by itself, it suffices that whatever it says, nobody should query it except that there are certain procedures that it did not follow.
Yeah, according to their own constitution.
According to their own constitution. Or let's talk about Section 87 of the Electoral Act in terms of primaries. So that is the basis of the decisions, several decisions of the Supreme Court, that the conduct of primaries of a political party or who it presents, or who the political party presents as its candidate, is an internal affair of the party. That is why the Constitution uses the phrase sponsored by a political party. So it is not of a member of a political party or an organ of a political party to decide which candidate is to be sponsored by the political party, because the political party is a legal entity, a person on its own who says, this is who I am presenting.
Okay, look at this scenario. Yes, the political party presents the candidates according to the Electoral Act which we apply in this country. And yes, you can conduct your affairs, you can be sued or sue, but you have your rules and regulations which you should follow.
Yeah.
What if the court then says, well, this group, the Oguebego EXCO, is the authentic group, none other. And so you should work with this group. And then the party goes and works with another group, perhaps supervises their elections and runs to their own list. Wouldn't something be wrong with that?
No, there's nothing wrong with it. If it is my responsibility to do a thing, and I do that thing, it does not matter whether you are my friend or you are part of the organization and I did not make any reference to you in doing that thing that is my responsibility.
Even if your constitution says you should or you must work with
no, the constitution, and in this case, the constitution did not so say.
No, let me try to understand.
People claim that the PDP constitution says that.
No, there is no way your constitution will supersede the clear provisions of the constitution or the Nigerian constitution or the decisions of the Supreme Court. But the Supreme Court has decided that it lies with the party. Take that decision, that principle clear.
We'll get that part, but would it be wrong for those who are interpreting this and saying, well, if the Supreme Court says the Ogwebego-led EXCO is the authentic group recognized by law within the party, wouldn't it be strange that their own group is saying, look, we had our own primaries. We conducted primaries in the party as stipulated by the party rules, of which
let's not waste time. Let's not waste time in that train of thought. It doesn't play any part in this situation. Even in the Supreme Court decision, if I read it, thankfully I got the full judgment last night and I sat down and I read it. Inside of the judgment, the Supreme Court was very clear in saying that the case before it was not as to the power or authority of an organ of the party to conduct primaries. That the case before it is as to the sanctity of the decision of the Federal High Court down there regarding the state ESCO. And if you also follow that judgment, the Supreme Court now also raised the issue, accepted the issue that was brought before it by the counsel to Ogwebego himself. At the Court of Appeal, counsel to Ogwebego has come up with these issues that their own candidates should be used as the proper candidates in the elections. But at the Supreme Court, it went contrary to that request at the Court of Appeal. If you read it clearly, it now formulated its own issues separate. Probably it got the idea that if it had maintained that line of reasoning, the Supreme Court may deny it its request. So it framed it clearly, and it stated, the counsel to Ogwebego clearly stated that the issue before the Supreme Court or before the court was not as to whether Ogwebego has the right to present a candidate or candidates, but as to whether Ogwebego is the rightful leader of the state ESCO. That was the grounds of appeal, one of the grounds that the counsel to Ogwebego himself formulated, and so the Supreme Court agreed with. They
cannot then say, by extension, having recognized us, you have to recognize all the other actions.
No, you cannot, because it was even directly discussed by the Supreme Court that what is before them is not who is the proper person to present candidates or not. That is not before the court, and that the appellants now Ogwebego, in framing his issues, they have brought the issues clearly, and they are in agreement with the issues that the appellant has brought forward. But that what should happen is that the decision of the Federal High Court that states clearly that Ogwebego should lead the state ESCO is sacrosanct, and it is still pending on appeal. So what the Supreme Court has done, and what Ogwebego should do, is to go back to the Court of Appeal, the appeal that is still pending, and argue this issue of the fact that he wants his own candidates to be used to replace these other candidates who have already been sworn in.
Before doing that, what about him getting an interpretation of this judgment?
The judgment does not need interpretation.
But if it's not clear to you, it's not clear to you.
It's clear. It's clear. It doesn't need interpretation. The judgment is absolutely clear. The court said that what is before them, we are here now. What is before you? Who is before you is Ikechukwu. There's no question as to who is before you, whether it is John Ikechukwu or John Amos. Who is before you is Ikechukwu. The Supreme Court clearly stated that who is before them is Ikechukwu. So there's no need to start talking about another person. That is the analogy you can use to understand this.
But then if the man has suffered, because it was said that the Supreme Court upheld the judgment of the High Court.
Federal High Court.
Of the Federal High Court.
Yes.
So what has happened? What has happened within that time when he suffered the injustices suffered? All the actions that have been taken on his behalf as as chairman.
Let me also refer you to the case of Rotimi Amechi. In Rotimi Amechi's case, just before they got to the Supreme Court, the counsel to Rotimi Amechi rephrased his requests, his prayers, and asked that Rotimi Amechi be declared the governor, the winner of the election. That means instead of leaving it silent, the council to Rotimi Amechi went ahead to ask for what you call an order. Let me just be very plain about it. The order of court that Rotimi Amechi be declared winner. There is no such demand on the part of the council to Ogoegbego before the Supreme Court. In fact, it had that demand at the Court of Appeal. But at the Supreme Court, it clearly by himself, there are about 5 lawyers there, by themselves clearly stated that what they want the court to decide is not whether the power is with Ogoegbego to present his candidate.
Maybe that was because they thought, I don't know what the mind of the thinker and the lawyer was, but it's possible that they thought that it would naturally flow. That if this man is declared chairman, then consequentially it should flow that his candidate
now
will be
you have
recognized.
used the word I've been trying to avoid.
Yes.
Consequential order. Consequentially, you don't. The court is not a Father Christmas that will give you a consequential order that did not emanate from you. And in any case, the court also stated there that it is settled law that a person who is not a party to a case cannot suffer detriment or benefit from the case, except that party can be stopped by his conduct or is a privy to a party. These two situations is that you are already aware, you should be in court, you have been asked to come to court and you decide to stay back. That is estoppel by conduct. Or that you are a privy to a party. In other words, somebody is your agent and the person is already in court. Whatever that person achieves in court, you bear the burden. Where these two situations do not apply,